morning.
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 Would you like me to take a seat?
Yes, please. Yes.
Lots of papers with you, with lots of answers, I hope.
Hopefully that's not going to raise the committee's hopes about how well prepared I am across the board.
They're high powered.
Okay, folks are all very welcome.
Thank
For members' benefit, we have before us Ms. Arlene Elliott, the President of the Law Society, Ms. Catherine Mackay, the Deputy Chief Executive, Mr. James Cooper, Council Member of the Law Society, and Mrs. Mara Neeson, Director of Client Solicitors Complaints for the Law Society. We're just going to go straight to questions. Obviously, there has been a high-profile. This has been a high-profile case in terms of the Project Eagle portfolio and the sale of it, and we are certainly conscious of the NCA investigation and do not wish to compromise that in any shape or form. And just to put it on the record as well, that the NCA have not raised any concerns about how we have conducted our inquiry to date. I suppose, the first thing that jumped out at me in terms of the Law Society and this particular case was the statement that was issued on the 7th of July, and there was a correction. The first statement said that Mr. Coulter did not renew his practicing certificate and therefore could not investigate him. There was then a corrected version put out in which it was said that the Law Society could investigate Mr. Coulter. Now, the concern I would have in terms of process, and strictly process, is that this particular complaint had been made in January, and the statement almost infers that by July you were not clear whether Mr. Coulter could be investigated or not as a solicitor.
Well, if I may, can I firstly thank the committee for giving us the opportunity to respond to the written questions. I think the committee obviously appreciates our difficulties in terms of giving any particular details in relation to our ongoing investigation, and it is very much appreciated that the committee understands the difficulty we are in respect of giving any particular detail. In relation to the first statement that was made on the 7th of July, it is factually correct that Mr. Coulter remains in the role of solicitors. It is also factually correct that Mr. Coulter is not a practising solicitor. I suppose, being a lawyer, those are terms that are very familiar to me, but maybe not to the general public. But essentially, when a solicitor, or to be a solicitor, one must be admitted to the role of solicitors, must be placed in the role of solicitors, and must be in receipt of a practising certificate, which is issued on an annual basis by the Society. So, in order to practice as a solicitor with the public, you have to be in receipt of a practising certificate, and to practice without a practising certificate would be a very serious breach of regulation. So, I suppose to reiterate, Mr. Coulter, as he is on the role of solicitors, like any person who would be in the role of solicitors, is still subject to the regulatory powers of the Society. So it's simply a differentiation between whether Mr. Coulter is allowed or entitled to act as a practising solicitor.
But if the Law Society, from January, February, all the way through July, the Law Society were always in a position to investigate Ian Coulter, is the way I read this. So why did that statement come out in July saying that? It
should always be clear that when this matter was brought to our attention in January, we began and commenced a vigorous investigation. And that included all of the issues that were reported to us and our subsequent investigation into those issues. The statement was to confirm to the public that it is a matter of fact that Mr. Coulter is not in receipt of a practising certificate. He is not entitled to deliver his services to the public as a solicitor. But it was not to give any impression in any shape or form that Mr Coulter is not subject to the regulatory framework of the society. He is. Any single person who's on the roll of the solicitors can be regulated by the society.
So, was this a mistake from the PR company? Or
Well, no,
who
it's-
made this mistake?
Well, I approved it, so if there's a mistake that's made, it's mine. But the statement is not inaccurate. It basically states that Mr Coulter is not a practising solicitor, and when it was read by some members of the media as being a statement that we could or had no regulatory powers to investigate him, that was clarified in a second statement of the same day. So if I bring you down to 1, 2, 3, 4, the fifth paragraph, Mr Coulter did not renew his practising certificate in January 2015 and is therefore not practising as a solicitor in Northern Ireland. That's correct.
Yeah, but you also said the Law Society, Mr Coulter did not renew his practising certificate and therefore cannot investigate him?
No. No.
Okay, so...
The element of not being able to investigate people are those who are non-solicitors. We can't regulate non-solicitors. We can regulate anybody who's on the roll of solicitors. We can't regulate non-solicitors.
Okay. So just to clear up any confusion, was Mr Coulter being investigated prior to the 7th of July?
The whole issues that were reported to us from January were immediately investigated by the Society, and that includes all persons who are on the roll of solicitors.
When exactly did the Law Society decide to carry out an inquiry?
I am somewhat limited in what I can respond in relation to this particular case. What I can say is that the Society will carry out a reactive inquiry, if you like, where it receives intelligence, and I'm making this in a general fashion. Intelligence can come in from a number of different sources. Most commonly, it's actually from other solicitors. It can come in from other enforcement agencies. It can come from our reporting insurers. It can come from the reporting accountants. It can come from a variety of different sources. When we receive any intelligence into the Society in respect of conduct or queries or accounts, then that is immediately investigated by the Society.
I don't see what the issue is with that, because you have stated that Doohan's made a report to the Society on the 27th of January. Yes, there's an NCA investigation ongoing, but by stating when the Law Society then decided to proceed with an investigation, I don't think that's going to compromise the investigation. So it's very important we know when the Law Society decided to act on that.
It's absolutely the case that Doohan's made a report on the 27th of January, and it's absolutely the case that the following day the Society commenced further inquiries in relation to that.
I wonder, Chair, just in fairness to you, you said that you're limited what you can say about the investigation. Maybe you want to just tell us why that is. It might be helpful, just because we want to be patient and understanding, but we only have a certain amount of patience. So maybe you want to tell us why you find it difficult to answer questions about the investigation. Maybe that might help as a preamble.
Well, I suppose by and large the committee will appreciate that when an investigation is ongoing, I don't believe there are any regulatory bodies or investigative bodies who would normally make comment in respect of the contents of an ongoing investigation. They wouldn't do so because it may very well compromise that investigation, and for those purposes we don't comment on the content of an investigation, and we very much consider that to be in the public interest, because primarily to fulfil our role we have to ensure the integrity of an investigation, ensure due process, and make the gather as much evidence as we can, make our decisions thereon, and if those matters are particularly serious, they will be referred to the Solicitors Disciplinary Tribunal, and when there is a referral to the Solicitors Disciplinary Tribunal, we will prosecute. So we have to, I suppose, ensure that ultimately, from the commencement of an investigation to the conclusion of perhaps a hearing by the Solicitors Disciplinary Tribunal, we have not done anything which would compromise that progress, if you like.
I mean, I understand that, and I think that's a good foundation on which to build, but you would accept that we might be better judges of the public interest in the Law Society?
Well, the committee, I suppose, has a different role in terms of fulfilling expectations of the public interest. I would assume that the committee's role is to check performance of the department and to, I suppose, review how bodies such as us perform. But I wouldn't say it's the role of the committee to become involved in the details of an investigation. Can I just say, you know, if it is of any assurance, that when this particular matter is concluded, in whatever way it is concluded, I am more than happy to come back before this committee to give greater details. But I am somewhat hamstrung in...
Just to go back to the question, do you think you're a better judge of who, that you're a better judge of what's in the public interest than we are?
Well,
Just a yes or no, thank you. I've already asked you, like, you've got 2 preambles, just a yes or no, are you, aren't you?
No, I don't think...
You aren't. Well, if you aren't, we will decide then.
We
will decide, if you don't mind, in this committee what's in the public interest and ask the questions. I think you should decide what's in the interest of the Law Society. And the feeling is that it's in the Law Society's interest to obfuscate, to delay, and to hide behind an inquiry. So we respect the integrity of your inquiry, but don't block our inquiry.
Could I just add, just to...
Well, let me finish. There'll be plenty of time, so for everyone. I think there's space for the Law Society Chair to do their work and for us to do our work. And we will get on better today if we're allowed to ask questions and get some answers. But if you're not going to answer any questions at all, it'll be better going home. And just to finish in this, the reason we're here is that we believe there were things that happened in relation to a dirty deal involving NAMA, at which a solicitor is alleged to have been at the centre of it. Things happened which I find absolutely bewildering, including solicitors' offices being involved in setting up bank accounts in Isle of Man with millions of pounds in them. So we're here to investigate not only the Law Society and solicitors and speculators, but we're investigating politicians, because very sadly the spotlight falls on this institution, and we're determined not to allow any of us to hide behind obfuscation or delays or any other excuses. So when I say that we want to get to the truth of this, believe me, it may not reflect well on this institution. So we're up for that, and we would like the Law Society to cooperate in that. Yes, please.
I was just going to say, and I want to reassure you that the Society is extremely anxious to be as open and transparent as is possible in these issues, and to assist your committee. And it has always been thus. The issue is that we are constrained, just like any other regulatory body that carries out an investigation, that during the course of that investigation we cannot prejudice the investigation, and we cannot prejudice whatever that leads to. And that's well recognised right across the piece in regulation, not only by the Law Society, but by all sorts of other regulators, and indeed, in my view, by the PSNI. Any investigation of a private individual or a company has to be subject legally to due process, and that due process, in legal terms, does not allow the investigator to disclose matters that would prejudice those people who are investigated during the course of the investigation. That is the rule of law throughout the land, and we are constrained by it. It's unfortunate that we are subject to apparently some criticism because of that constraint. There are other regulatory agencies involved in this who've made it very clear to us that we are constrained in that manner as well, and that has imposed upon us these limitations. And we entirely appreciate that your committee finds that frustrating and uncomfortable, but that, unfortunately, is the legal position.
Well, I mean, just
And
on that point, Mr. Cooper, I mean, obviously, you've made a great note of the fact that you're carrying out your inquiry and you don't want to wish to comment on anything which may prejudice the trial. What I asked was when and how did the Law Society decide to carry out an inquiry? And that's not going to prejudice any case. Now, what the Law Society have already done, acting in the public interest, because the Society reserves the right, where it is in the public interest to do so, to comment on investigations in appropriate circumstances. I think this is appropriate circumstances, given the magnitude of this case. And the Law Society has spoken in detail about Mr. Coulter and the renewal of his practice and certificate. So I don't see why the Law Society cannot state when they decided to carry out an inquiry, unless you received the complaint in January and you didn't act until Mick Wallace made his statement in the Dáil at the start of the summer.
Can I absolutely make it entirely clear to this committee that we have been looking at this well in advance of Mr. Wallace making his comments in the Dáil. When the report was made to us on the 27th of January, we immediately, the following day, commenced further investigation into that.
And when did you decide to carry out an inquiry?
Well, the inquiry was, our inquiry commenced the following day.
May I ask, when did you alert the police?
If I can give a general outline in relation to our obligations under the law.
Just answer the question, please, Chair. Just answer. When did you alert the police?
It's an obligation of these. If you would allow me to answer, and you may understand what difficulties I have in basically explaining my position, but essentially the Society, as in conjunction with all solicitors, have obligations under the Proceeds of Crime Act 2002 to make a report, what they call a suspicious activity report, if there is any suspicion of an economic crime. And if there is a suspicion or indeed knowledge of an economic crime, that report is made to the NCA. The NCA act as a gatekeeper in respect of how that report may be progressed. So should it go to the police, revenue or any other appropriate authority? Okay. If a report is made by the Society or any solicitor, it's actually a crime, a tipping off crime, to advise whether or not that report has been made. So I am hamstrung in relation to what I can say that will allow me to keep within the confines of the law.
So, Law Society, lawyer, layman, Prince Pauper, if we know that law has been broken, we're obliged to report it. When did the Law Society inform the authorities, the police, that they believed that the law had been broken? On January, what? We're talking January 27th here, or 28th? Did you do it on 28th? Was it 29th? Was it July?
Well, for starters, please don't make any assumptions about what precisely was reported to us on the 27th. When any report is made to us, we immediately investigate. And when we investigate, we have to gather all of the appropriate evidence. Sure. It is a matter of protocol that we obviously report to the police if we have sufficient evidence that would give evidence in respect of a potential crime or otherwise. And that is our protocol, and we always abide by our protocol.
So you did report it to either the police or the NCA? I
can't confirm that without committing the offence of tipping off.
The offence not that. Did you not say the offence was that you couldn't give us the time of when you did that? But
no.
You actually report it?
It is actually an offence to report at all or to advise at all whether a report has been made.
We may need to suspend this, Chair. This is Alice in Wonderland stuff. If representatives of the Law Society can't tell us that they alerted the police to what the general public believes and what we now know, what our allegations of law breaking are being investigated, if the Law Society can't tell us that, we need some legal advice, because my feeling is that there isn't a police officer in the land who would say that the Law Society would be in trouble for saying to a committee of this Parliament, which is acting in the public interest, that they did alert the police to what they thought was law breaking.
When everyone now knows the NCA has been investigating this.
Yes, I'm going to there.
The other way might be to say, did you follow your protocol?
We followed a protocol.
So,
And we have been in contact with the NCA, and we have sought consent to disclose to this committee as to whether or not we abided by our reporting obligations.
Just clarify that again in terms of the consent from the NCA.
We have approached the NCA and request confirmation that we can provide such information to this committee as to whether or not we have abided by our reporting obligations. So if the committee has further questions on that, then the committee should raise that with the NCA.
So the NCA have effectively vetoed you from speaking to this committee?
Well, the NCA have not given us confirmation as to whether or not.
They haven't vetoed you? You know, we can play games with words here all day.
I know, but you appreciate the
No, but I
difficulty.
mean, at the end of the day, in terms of dates, in terms of whether you spoke to the police or the NCA, that is not going to compromise any prosecution. You know, the man and woman in the street know that. Now, you're all from a legal background, and they can come in here and pull the wool over our eyes. We do require answers. The public needs answers in regard to this, and these are reasonable questions. This isn't going into the minutiae of this particular case, and it will intrigue the public that there seems to be a stonewalling from all directions in regard to this particular case. We're all aware of the rumours that this particular inquiry wants to be shut down from a number of sources. So I do believe the Law Society needs to be more upfront and honest. There's to be suspicion based on the Law Society
Absolutely.
as well.
And can I absolutely make it clear that as far as we are concerned, we have abided by our legal obligations in respect of reporting, okay? And that should be absolutely clear and understood by this committee and by the general public. Absolutely, that is the case. But it is also the case that under the Proceeds of Crime legislation, you cannot reveal whether or not a suspicious activity report has been made. And I am a lawyer, I must abide by the law. I am more than happy to furnish a copy of the legislation to the committee, and the committee may look for further advice in respect of it, but that is the position.
John?
Thank you, Chair. I'm not maybe very hopeful. It was around those issues that you're confident that you've followed your protocol. Who's actually investigating the complaint?
The NCA are investigating it, and we continue to investigate.
And is the identity of the person available, or is that a secret as to who's investigating it on behalf of the Law Society?
Within the Law Society structures, basically we have a regulatory team. I suppose to give a fuller explanation, the Society is operated by a council of which there are 30 people. Those 30 people are elected and they're members of the profession. The business of the Society is split into our regulatory committees, which comprise of Home Charter, Professional Ethics and Guidance, Financial Services, PII and Client Complaints. Council members sit on those respective committees, and then we have other co-optees that also sit on those committees. So the committee that ordinarily deals with conduct matters is the Professional Ethics and Guidance Committee. That committee oversees an investigation and makes decisions thereon, and if the committee is considers that there has been defalcation or a very serious matter.
Sorry, there's a word there I've never heard in my life before.
If there's been embezzlement, in essence.
English would be helpful.
If there's
I don't want to annoy another Arlene, because all the Arlenes in my life are very powerful women, but I just want to get that.
I don't know if I'm
Well, you're
one of them.
correct in that assessment. I have some experience of it.
So if there has been essentially embezzlement or something of a very serious nature, then ultimately the committee refers that matter to the council, and the council will then make the decision as to the exercise of the regulatory powers under the solicitor's order. So there is no, I suppose, an investigation does not rest on the head of one person. It is directed by the Professional Ethics and Guidance Committee.
And on your protocol, you said you've followed your protocol. Would that have been during the entirety of this process, or at when this came into the public domain?
No, during the entirety of this process. Essentially, when a report of any nature comes in, and again, this is just generally how we deal with all conduct matters, that is investigated, or an investigation is commenced by a regulatory team, but that is overseen by the Professional Ethics and Guidance Committee, and that is monitored throughout.
Yeah, but so that's continuing to be investigated, and as Mr. Cooper pointed out, you know, in line with other regulators. I think it will come at a very crucial stage as to when you either referred it to the police or to the NCA. Presumably there would be no difficulty if it had been a straight referral to the police rather than to the NCA. So I'm assuming it at some point in line with your protocol was referred to the NCA. It will be a note to this committee as to whether that was before or after this came into the public, and goes to the very heart of whether this committee, or more importantly the public, should have any confidence in the Law Society as a regulator. I mean, we currently, and the Chair has made this point before, we currently have a legal complaints bill before us, and I have to say, so far what we've been presented with on that is very light touch regulation. This would suggest that you would have a very strong case to get public confidence restored in the Law Society.
Well, you know, I suppose, as I've said, Mr. McAllister, really, I think it's unfair to jump to conclusions at this stage whilst an investigation is ongoing. I am more than happy to come back to this committee when this whole matter is concluded. More than happy to do it.
Could I just comment on your remark about the draft bill being light touch? I mean, in fact, it isn't light touch. There is extremely powerful powers in Article 4 of the draft bill to direct the Oversight Commissioner to make a report to the department, which is your department, on any issue that the department directs. And that insertion in the bill is, in fact, is extremely powerful, because it enables any concern about the ongoing operation of the Law Society as the in-house regulator to be subject to scrutiny and accountability straight back to your department, and also to direct in the medium or long term any regulations that the government feels are appropriate in the light of poor performance, if you like, as a regulator. And the Bain report, having been very satisfied, first of all, as to the history of regulation by the Law Society, secondly, by the nature of this very small jurisdiction in comparison with, for instance, England and Wales, were very, first of all, comfortable with the Law Society as being a regulator, and that was a very broadly based committee with consumer rights, economists, all sorts of different people on it. But they concluded that to put in that particular power satisfied the requirement to have oversight and independence governing how the Law Society operates as a regulator. So I have to disagree with you. It's not light touch. It's in fact extremely powerful.
Well, I think, Chair, the concern would be being both the regulator and in charge of effectively registration, that there's two. I mean, the point I'm making, and goes to the heart of this entire thing, as to whether, and you're unable to shed any light, and I suspect the Chair, along with other members, are not exactly feeling a huge amount of accountability and scrutiny coming towards us from your evidence so far. The point in this entire case seems to be as to whether there was like some sort of quid pro quo between the Law Society as to whether this was reported to the NCA or not, or if the money was returned. And the timing of all of that, I think, will be of incredible interest when it all would come out into the public domain, and goes to the very heart of whether anyone can have confidence in the job that the Law Society is doing, myself included, as a member of this Assembly, or indeed as a member of the public. That goes to the very heart of whether there's something the Law Society has been involved in this.
But just to finish that, first of all, we are very confident that when the facts emerge, at a time when the facts emerge and the investigations, not only by us but by the NCA, are open to public scrutiny, that our role will be vindicated and that we will be found to have regulated in this matter appropriately and robustly. We're confident about that. We're in the unfortunate position that we can't give you any more substantive evidence to back that up, but that is our position. We're also very much aware that under the powers proposed in this bill, if it were concluded that we were unsatisfactory in our regulation of this matter, or generally, that there are very wide powers open to government moving forward to actually regulate us. So we're alive to that issue, and the powers in that bill are there to deal with any factual conclusion that the Law Society is a bad regulator. But that nevertheless, we're in this very difficult position today, and we can put it no stronger than that.
Well, I suppose, could you confirm then at least that it wouldn't be appropriate if someone was to pay $7 million for professional fees on the solicitor's order, that would, if that was going to a non-lawyer, would that be wrong?
Again, can't comment on this particular matter, but it is hypothetically, you cannot, a solicitor cannot share fees with an unqualified person. That is a breach of the order and constitutes a crime, and that is absolute. We've provided in our response details in respect of the relevant section. And if I can take you to that. It's at page 12 of our response, and it details Article 28 of the order, and it being a criminal offence for a solicitor to share fees with an unqualified person. There are, as you will also see, certain exceptions. That is where a solicitor is effectively buying out the interest of a retired solicitor, or is working in-house in a department or something of that nature. But by and large, it is absolute that you cannot fee share with an unqualified person.
Just a quick point on that. Then you're saying that's the case, that you can't share provided it is professional fees. So am I right?
Sorry, come again?
They can't share if it is being deemed as professional fees. Am I right in assuming
cannot
then,
share a professional fee?
Am I right in assuming then that the sort of thing that would be looked into in a matter like this would be, has there been a specific invoice which details what the professional fees are for? If that was paid on the full amount, and
yes,
that's the sort of thing that would be looked
absolutely
at to determine whether or not
yeah,
potentially money could have been shared if it wasn't all related to one invoice.
absolutely.
And have the Law Society seen those invoices?
I can't comment on this particular case.
Hypothetically, have you seen them?
Good try.
Thanks, Chair.
That's great.
Good morning.
Morning.
No, it doesn't seem that long ago we were around at your place talking about another issue which has been touched on this morning, but a lot of this conversation sort of rings a bell again. I do have some sympathy with your position, but could I ask you just to explore the position of someone on the roll Can they remove themselves from that role?
You can only come off the roll if you die. And
That's
that
irrefutable.
does happen. Or you can make an application to the registrar to be removed from the role. The registrar has discretion to grant that, and the sort of issues that the registrar would look at would be whether there is any ongoing regulatory investigation, for example. So if there was an ongoing regulatory investigation and somebody applied to come off the roll, then that application would be refused.
You have anticipated my second question.
Well, it's common sense. We're not going
It is,
to
but sense is not a very common thing, let me tell you.
Well, you know, I mean, I suppose I want to assure, as Mr Cooper has already stated, we are in a very difficult position, and I want to assure the committee as much as I can that we have very vigorously been, persistently and vigorously been looking at these issues, and, you know, we're really hamstrung about what we can say over and above that.
No, I do have sympathy with your position, yeah. Thanks, Chair.
Thank you, Leslie. In terms of the funds that were referred to, are they secure?
They are secured.
Are they secured?
For legal reasons, I can't say.
In general terms, hypothetically, how do you usually secure funds?
It depends, and again, absolutely hypothetically, ordinarily, if there are client monies at risk or in jeopardy, or there has been dishonesty of some nature, then it is likely that the Professional Ethics and Guidance Committee would make would come to the view that the society should intervene in a practice, and will refer that for decision by the council. The council then has powers to pass resolutions under Article 36 of our order, so that we can effectively intervene in a practice to essentially ensure that client funds are kept safe and are not jeopardised.
In terms of the complaint that was made, it was a self-referral by Tuhans. In terms of when you investigate a case like that, is it a case of going in to the firm and is it a blanket audit? Or is it more restrictive?
It depends on, as I said, we get a number of different reports. We can get self-reports, but reports from other sources. The reports can range from minor matters to obviously much more serious matters. But if it is obviously something that's serious and of concern, our powers range from inspection, going into practice, uplifting deeds and documents. There will be essentially a full audit carried out upon an inspection to test the veracity of what has been advised to us, evidence gathered, and sometimes a report may come in of some nature and it leads in a different direction. It's not uncommon. But we will fully investigate that. I mean, we're essentially, we have a very heavy regulatory obligation under the Solicitor's Order in 1976. I always remember that date because it was the year I was born. But until that, I suppose the Society was set up in 1922, and it wasn't until 76 that a regulatory regime was put in place. And when that regulatory regime was put in place, it placed a very heavy onus on the Society to effectively regulate our members. And I suppose part and parcel of that assurance to the public was also that a master policy would be in place, so that every single member of the public who goes into a practising solicitor has the assurance that if that solicitor acts in a negligent fashion or whatever it may be, that there is an appropriate insurance policy in place, and we have to regulate that is in place, and we also regulate or hold a compensation fund. So it is of deep interest to the members of the profession and to the Society that we are a good and effective regulator, because if we fail in our job, it actually has serious financial repercussions on our members, and it also has reputational damage.
In terms of any such audit that you may carry out on a law firm, would that include any tapes that the law firm would have too?
Well, ordinarily when we carry out an audit, it is of the accounts and files, etc.
Which would include tapes?
You're asking me really a very pointed question in relation to this particular matter, but we have powers to uplift deeds and documents and, I suppose, other materials that may be relevant to.
It's okay. Martin?
Yeah, look, thanks very much. I think we may have exhausted some of our avenues, but thanks for coming in. Mr. Cooper didn't get to thank you earlier on for your comments. Just you understand where we're coming from. We're trying to investigate a deal which we believe was which were kickbacks. There was a sweetheart deal. There was embezzlement, fraud, a dirty scheme. We believe that. We're investigating it because it's being alleged that at the heart of that were politicians benefiting, huge personal gain, mammoth sums involved in this. That's why we're here. But of course, also in the middle of that dirty deal to sell public assets at less than public value to the loss of the public purse, but also to defraud people and to commit what may have been a crime is someone who is at the heart of your association and society, a colleague of yours. So that's our interest. We have some sympathy for the Law Society, but the public interest, in my view, outweighs the Law Society's interest in this, and therefore I think we have to say we're dissatisfied when the Law Society won't answer questions. It's a rigorous and vigorous investigation, still isn't finished. August still isn't finished. Doesn't seem that rigorous to me if it hasn't been finished by August. Will it be finished this year?
I can't
say.
I can't
so this rigorous, vigorous legal. I know that lawyers do charge by the hour, but to not be able to say it'll be finished this year beggars belief.
With respect, we can't say whether it's going to be.
Excuse me, Chair.
You know, so I think it's unfair.
And you will have, Chair. I hope you'll give Ian all the rope he wants with which to hang himself later on.
I'm not hanging myself.
And this,
in any way, he can be sure.
I think you should intervene there.
We need to ask. In this vigorous and rigorous investigation, which is being carried out by the Professional Ethics and Guidance Committee. I presume that's a trusted body of senior, veteran professionals in your association who are seeing this. And was Ian Coulter a member of that committee?
No.
It's the first straight question answer we've got all day.
I think I've had or given a few other straight answers.
So this Professional Ethics and Guidance Committee, I think we wish them well. We bless them with alacrity that perhaps they could get to the core of this quickly so that we can get the answers we need. But I think that in the non-answers, maybe we've got more examples of the wagons being circled, Chair, and the failure to let the public know what happened in this. So let's get to the truth of this. We're determined to find out what happened in this deal. And I don't care how many people come here and say, I can't answer the questions. We will do our part and find that out along with the police and along with the NCA. So thank you, Chair. Ian, Chair, the floor is yours.
Thank you very much. And I can assure you, Chair, and others that I'll not be hanging myself, nor will anybody else. But nonetheless, from my perspective, I want to thank you for coming today. And I know it's a bit frustrating for all the members when we get responses from different people to say for different reasons we can't come. At least you've came, you've done your best to answer, some questions and those that you can. But for me, this committee can't say that we'll be finished in 2 weeks, 3 weeks, 3 months, 3 years. Well, mightn't even be here at that point, but
3 weeks.
Nonetheless, I think it's important that every effort is done and that the public interest is seen to be that yourselves are doing what you can to ensure that the outcome is as satisfactory and that you have went through this in as rigorous way as possible. I do welcome the fact that you have committed to come back to the committee to inform us of your findings, and I think it's important that we do welcome that. But I think it's unfair of others to, suggest that just because you can't give a time scale that you're not going through the rigours that you are. So from my perspective, and I've no doubt most of the members of the committee, if not all, want to see this come to a conclusion. And I think it's important that people are given the time, but understand the urgencies and the public interest that there is around this. So I'm content to take your word that you're investigating this, in as quick a fashion as you can, but I understand the difficulties that you're in, given the ongoing investigations that are going outside of your own body as well. So, thank you, and hopefully we can get a resolution sooner rather than later.
And thank you. And certainly from my point of view, I similarly wish the committee every success in its own inquiry. And, you know, similarly, there is not a member of the profession, nor indeed the public, who wouldn't look to have revealed any improper conduct by either politicians or solicitors. And if there has been improper conduct by solicitors, it will be dealt with by us.
I just think it's worth reiterating. I mean, it is very much in our interest to make sure that the public are satisfied in the end of the day that we have been vigorous. Our profession has a reputation, and that reputation has to be maintained. And we, as the representative body of the profession, are fixed with that responsibility. And so in any conduct we carry out, we do not want to suffer reputational damage as a regulator or a representative body. So it is very much in our interest that when this matter concludes, that the public and politicians obviously are fully satisfied that we've discharged our responsibilities properly and in the public interest. So we're in common ground when many of you talk about the public interest. We have that as our primary objective as well.
Thanks, Chair. I was thinking when you're talking there about reputation, politicians, solicitors and estate agents all get fairly harshly done by at times. It was just to really follow on from one of the Chair's points around Tuan's involvement. If A&L Goodbody, with the solicitors handling the actual legal work for the sale, what were actually Tuan's doing?
I can't answer that.
But everybody's being...
I can't answer that. You know, I can't answer questions to do with an ongoing investigation.
It's just...
How many times do you need to be told?
And, you know, and can I say I don't like saying that? You know, I genuinely don't. I do believe that, you know, where possible you should be upfront about things, but that is just the position that we're in, unfortunately.
Well, I mean, I'd hope maybe, Chair, probably like other members, we'd have made maybe slightly more progress, and I do hope that Mr. Cooper's point that when all this goes out in the wash at some stage, that everybody can look back and hold their head high. But I do think it will, and will have to have a major impact on the committee looking at the level of regulation we need, and whether we need a tougher model like probably in England that they would go for rather than what we maybe opted for. I think it will have an impact on that belt. You may get lucky and this place could be gone in a week. If you'd have held out maybe longer for a different date, you might have got a lucky break. Thanks, Chair.
I think we're due back. We're due back in 3 or 4 weeks' time, and you know,
Maybe lonely.
we're not. Let me reassure you, we are not wishing your early demise in respect of our future appearance around the bill. We are very content to defend the shape of the bill as it has emerged, and to convince you that it is entirely appropriate, notwithstanding this issue that has arisen in the meantime.
Thank you.
Can I ask, and we've asked this in written form as well, I think it would be a benefit to the public, who in a law firm is legally authorised to handle the firm's accounts, including making transfers from those accounts?
Well, as a matter of law or under the solicitor's order, all principals are responsible for client accounts, regardless of whether the partners in a practice have control over those accounts. So it is a matter of strict liability. So, for example, if there was client monies that went missing as a result of the activities of one partner, all partners are responsible, regardless of whether they had anything to do with it or not. And all of those partners would be requested by the society to immediately reimburse the client monies with absolute immediate effect. And if the firm was unable to reimburse those monies immediately, the society would then intervene without hesitation. So that is essentially the strict legal parameters upon which every firm must operate. Within a firm, they will have their own internal controls to ensure that there are checks and balances when money is utilised from client accounts.
Martin?
Sorry, since you brought up money, and it is a shame to leave without discussing money, the fee paid by Service to Tunes was, or to Tunes or to Coulter, whatever, was I think 7.1 million around that area. And that isn't in an account controlled by the police, that's in an account controlled by a law society. Am I correct in that?
I can't answer that question.
Okay, I think you did answer that earlier on. You said
I said it's secured.
It's secured, okay.
The monies are secured.
So you don't know where it is, or you do know where it is?
We know where they are.
Is it in the? Is it gathering interest?
I can't answer any further questions.
Do you have any idea what the value of the money is now?
Can't answer that question.
Okay.
If I may,
Is it possible? It probably is the most interesting point in all this. There's 7.1 million sitting out there. It's possible that may go back to Tunes.
I can't comment on that.
Okay. Possible some of it may go back to.
Can't comment on it. We got a telephone call this morning before attending here from the Deputy Senior Investigating Officer in the NCA, reiterating that we should not answer any questions in relation to this particular matter.
But when we understand that, if our criteria.
What matter in particular?
In relation to the ongoing investigation.
Which is anything to do with it. That could be
In respect of Tunes and Ian Coulter's departure from Tunes.
Sorry, could you tell us just who called you again? Sorry, just can we get a note of this? Who called?
The Deputy Senior Investigating Officer in the NCA.
What's his or her name?
Mr. Birmingham.
Mr. Birmingham. That surely that's a made-up name. So, Mr. Birmingham rang. What time did Mr. Birmingham ring at? Get that?
You give me a second.
From a withheld number, I'm sure.
It always, it's like the courtships, the final, just when you're going out the door, you ask, can you marry the daughter? This is the most interesting thing we've heard today. Yeah. That at 9:30 this morning, or you want to tell us that? Sorry, what time?
10:45.
Okay. So we sat at
10.
Oh, that's when we received a message.
I asked for a message to confirm the telephone conversation.
Thank you. Would you read out the message?
It says, "Hi Catherine, Richard here. It was good to talk earlier. Around our correspondence, we would be happy for you to say, should you wish, that LSNI are cooperating with NCA in this matter, and we're mutually keen to ensure that the integrity of the criminal investigation is protected." Okay, now that itself is very interesting, and I know Chair, you're in touch, and Deputy Chair in touch with NCA, but that's not what we're told. You told us that the NCA said you shouldn't answer any questions relating to the investigation, which isn't what the text message said, but that may be understandable. Maybe the text message doesn't go into it. But what I would say is, Chair, that's very interesting. Why is the NCA making calls in relation to investigation? Moments before we sit, it
might be in response to a call.
It could be.
Can I say we have been cooperating with the NCA since their involvement, and that cooperation has been ongoing, and certainly it was a concern for the NCA that we protect the integrity of this investigation by not revealing any particular details in relation to it.
And we're at one with you. I mean, we're doing the same. We're cooperating with the NCA. We're if there's any criminality of this, we wish those who've been involved in criminality be brought to book. So we're exactly on the same page in that. But that has nothing to do with where the £7 million payment is, because that, whether there was wrongdoing or whether it was as pure as driven snow, where is the £7 million? How much interest is it accruing? Can it possibly go back? My view, it should be given back to Service. In my view, this was a payment which had nothing to do with a transaction. But that has nothing to do with it. It doesn't matter. The money is there. Is it under the control of the Law Society, under the control of the police? So what's that got to do with the investigation?
Well, again, can't confirm the details in relation to this investigation, but it's a matter, of course, that any client monies, for example, any interest that accrues in it on client monies is the client's, belongs to the client.
I think what would be of use, obviously you are in regular contact with the NCA, and the approach of a number of witnesses is there's an NCA investigation ongoing, we can't say anything, okay? There are questions here that could be answered that would not compromise the investigation or any future prosecutions. So I think a conversation does need to take place, and myself and the Deputy Chair will be meeting with the NCA shortly. But a conversation needs to take place between yourselves and the NCA in terms of what detail you could release in the public interest that will not compromise the case, because obviously the Law Society's reputation is being affected by all of this.
Absolutely.
And I do believe there's information that the public would be interested in that will not compromise this particular case. So I think it'd be worthwhile if you were to go away from this meeting today to relay that message
I've
to the
absolutely
NCA.
no difficulties with that.
We will reiterate that in terms of our committee's message to the NCA. We do not want to compromise the investigation, but we do not want to see a blanket shutdown as well, because there's huge public interest in this. This is the biggest financial scandal we've ever seen in the North, so there's a big public interest. The public want answers, they want accountability through the appropriate mechanisms as well, but there's a balance to be struck. And I think that the NCA and yourselves need to have a conversation about that.
Sure. Could we, in cooperation with the NCA, I don't understand why the NCA isn't ringing you before the meetings? Because surely they should be saying to you, if they want to call everyone, why aren't they calling us all before meetings? I think it's extraordinary they'd be making calls before meetings, telling people what they should and shouldn't answer. But I do think that maybe there's a need to come back after we all consult with the NCA and answer some questions, because it beggars belief that £7 million gathering interest could go back to tunes. I mean, how many thousand hours would a company have to bill out? Even our most expensive company, how many thousand hours would they have to bill out to earn £7 million? Probably 1,000 years. And to suggest that £7 million, which whatever happened here, criminality or not, we know it was a dirty scheme of some type, that may go back to a firm of solicitors of Belfast with interest when this is finished is staggering. But I leave it like that. Thank you.
Okay, members, any other questions?
Thank you.
Thank you all very much.
Can I thank the committee for their time and patience
Thank
this
you.
morning?
Well, some of us.
Thank you. See, sent it.
Thank you very much.
Thank you.
Thank you, folks.
Martin, you'd have made a suggestion that we would call the Law Society following
Well, I mean,
conversations with the NCA.
I'd like to probe the stuff that they're allowed to talk to us about. So this is a wee bit, it's getting well, we're still live, Chair, but it's getting a wee bit silly. If the NCA is calling witnesses before they come in and telling them effectively not to cooperate, that the NCA is telling us, stick to the criteria, guys, and do your job. There's room for us all to do the job. So we need, Mr. Wells suggested previously bringing the NCA in. I presume that's in process, but Mr. Birmingham, Mr. Richard Birmingham, needs to speak with you why he's calling our witnesses minutes before they appear to us to tell them, as Arlene said, not to answer any questions, because that's not the criteria. And questions, for example, about money being held in escrow are totally irrelevant, immaterial to the initial investigation. They're very material to the interest certain people may have in the outcome of this, which is a different matter. If there's a possibility that £7 million ends up going to people in business in this city. But I just think that we need a little bit more, perhaps chat with the Law Society about what can they help us with, rather than this blanket refusal.
Mr. Chair, I think this puts into stark contrast. We do need the NCA here in public session. I understand that it's a meet and greet between the chair and the deputy chair, and that's acceptable. I think we need to go a step further, because, and what has been said is actually maybe the only significant point that came out this morning was this conversation between the NCA and the Law Society. I think that's very interesting, and I think we need them before us. So, I mean, by all means, go ahead with your meeting, but I would be suggesting we bring them to this committee.
Okay, members want to agree to write to the NCA again about that particular point?
I think we'd like to see Mr. Birmingham.
Yeah.
Chair, there is correspondence.
If it's a real name.
Chair, there is correspondence in members' packs today from the NCA, which
NCA,
highlights
subject to section 44.
if the committee minded to do that.
Sorry, Chair, did you want to do with the correspondence with the NCA? What did it say? I didn't see the pack.
It's in the pack. The NCA said they wish to meet with the chair and deputy chair, but are not accepting the invitation to speak to the committee, essentially.
Yeah, but
That's not good enough.
they've indicated here that you will appreciate the investigation is at a very earliest stage of criminal inquiry, and as such we will be limited as to the detail which we can discuss, so as not to risk the prejudice of any subsequent proceedings. Similarly, it would be preferable to provide the briefing in private to yourself as chair and to the deputy chair. Please let me know if this is in order.
Chair, through yourself, on the basis of that, if that's the case, I appreciate that they're trying to steer who they meet and who they talk to. I think there's a possibility of widening and having a larger delegation go to meet them, and appreciate that there's representatives of two parties present there. I think we make representation from all parties around the table, and that's it will still be a chair's meeting.
Okay, we'll make that proposal to them. Members content?
Yeah.
Members also content for the briefing paper provided by the Law Society to be published on the committee website. Great. Scale of non-assets correspondence. Can refer members to pages 50 and 51 of your packs. Page 50.
From dear sir.
There's email correspondence from a member of the public offering to submit evidence to the committee review. I advise members this has been received following the committee's open call for evidence. Can I seek agreement to note the correspondence at this stage and write to the individual asking him to submit factual information relevant to the committee's review and its terms of reference?
Agreed.
Agreed. Item 5.2, can refer members to the email correspondence from a member of the public regarding HMRC bankruptcy proceedings and the behaviour of Cerberus. Advise members the issue highlighted falls outside the remit of the committee, and in line with usual practice, the committee cannot have a role to play in individual cases. I seek agreement to note the correspondence. Would it be appropriate to forward this to HMRC, or
If that's what the committee would like to do.
okay. Members content to forward this to HMRC for a response to the committee?
Yes.
Great. Okay, any other business, members? Can I remind members that it's meeting on the 1st of July. Members were advised that arising from the central agreement reached at the chairperson's liaison group from September onwards, committee staff will no longer be providing hard copy packs to any member. Members will be able to make prints from SharePoint as they wish, but it will be their choice and responsibility to do so. Also, we're awaiting response from Jimmy Bryson. Has anything?
I haven't heard anything back yet as of yet, Chair, so I think there's a response date of the 8th of September on that.
Okay.
So that would be next week, and it's just obviously to give time to consider the committee's correspondence into
In terms of the steps following that, when that's received, do we have any?
Well, when that's received, that will then obviously be put back for members for consideration. I would imagine that what we would need to do is review the detail of it in the first instance. Obviously, there again, it would be for the...
Would you invite Mr Bryson in my absence, Chair, but he's been one of the people who says that we don't want to invite him. We should just reiterate here that we're keen to hear from everyone within the criteria. If people stick to the criteria we have, they're all welcome to come forward, and that applies to Mr Bryson like everyone else. So I know that we've written to him, and if he wishes to come forward, he should come forward, but stick to the criteria like everyone else.
We did write to him on specific terms. There was specific detail last week.
Yeah.
Okay, members content to await that response and then consider further in terms of the appearance before the committee. Okay. Next meeting then, members, Wednesday the 9th of... Is there no meeting next week then, Phil?
Again, that's for members to decide.
Members, we'll just keep that open in case there's any other issues arising from today's proceedings or the ongoing inquiry. So there may be a meeting on Wednesday the 2nd. Otherwise, we'll be back to Wednesday the 9th of September. Meeting's now closed.
Thank you, Chair.
This is the Northern Ireland Assembly Committee Room 30.